Calling case 251851OM, People versus Alyssa Hall.
Morning, Your Honor. Jeffrey Canto on behalf of Ms. Hall. Waive formal reading, stand mute. Request matter be set for settlement conference and discovery order to enter.
Ms. Hall, can you state your name for me, please?
Alyssa Hall.
Did you go through your advice of rights with your attorney, Ms. Hall?
I did.
Okay. Did you have any questions about your constitutional rights?
No,
And did you allow him to sign your name to your advice of rights?
I did.
Okay. And so in front of me, I have an order for discovery. I will have that signed. We're going to be adjourning this for a settlement conference for your attorney to get the discovery or all the evidence that the other side has. For purposes of arraignment, I'll enter a not guilty plea. Ms. Hall, you're gonna have some bond conditions. You're to appear in court as directed. You have a $1,000 personal bond. I think I missed that. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any crimes while released. And you're to immediately notify the court of any change of address or phone number. Give me just 1 second.
I do have a question on that. My bond was returned to me.
You don't have to post any money.
Well, I know
personal
that,
bond.
but I thought all bond conditions were done because the bond was returned.
Well, Ms. Hall, we're doing the arraignment now, which is we hadn't done before. So she's going to give you the bond conditions, but the bond, the monetary bond is personal, means you don't have to post any money.
But you still have to adhere to the bond conditions I just stated. Do you understand? Yes or no? Do you understand, or do you need me to go through them again?
I suppose.
It's a yes or no question, Ms. Hall.
I don't understand how there is still bond conditions when my bond was returned, but that's apparently something else according to my lawyer, so it is what it is.
No, I'd be happy to explain it to you. So you're on bond. So whenever you have a pending case, you are out on bond. Instead of being in custody, you're out on bond. I'm giving you a personal bond, which means you don't have to post anything, but you still have to adhere to your bond conditions. You can't go and commit a murder when you have a pending case. Does that make sense?
Before we even hit play on the first case, understand this. Today's video is a masterclass in how courtroom behavior can quietly spiral into serious consequences. We've got 3 moments here, and each one escalates in its own unique way. First, you're going to see what starts out as a routine arraignment completely derail because someone simply cannot accept a straight answer from the bench. Then, we move into 2 separate hearings where defendants believe they're negotiating with the judge, only to discover that court is not a debate club, it's a hierarchy. And when you ignore that hierarchy, the outcome can turn ugly fast. What makes this especially interesting is that Judge Shackelford isn't even on the bench today. It's a temporary judge stepping in. Yet the tone, authority, and zero-tolerance approach feel identical. That's intentional. Because in a courtroom, it's not about personality, it's about order. Watch closely how small interruptions, attitude, and refusal to listen compound into something much bigger. And pay attention to how the judges repeatedly explain the rules right before enforcing them. Because by the end of this video, someone learns, the hard way, that court patience is not unlimited.
So this is a new case then off of that original case because I originally got that bond back and told that nothing further was going to happen. And then all of a sudden I was told I missed a court. So I'm still confused. Is this not the same case?
Okay, so we're gonna do a full arraignment, okay, Mr. Panto?
I'm just confused.
I understand. I'm going to go through it with you because that's part of the arraignment is to understand what you're being charged with. So give me 1 second. Let me
I'm
pull
being
up
charged for disorderly conduct at my brother's house. I understand that.
That's the
But
charge.
the day my bond was returned and they sent a letter stating nothing is going to happen at this time. And then
And I'm. Go ahead.
They have the right to review and file charges, which they did, and that's why we're at today's point.
all right, can we
So they reissued the charge, and I'm reassessing a bond, which means you have bond conditions because technically you're out on bond. I'm assessing you a $1,000 personal bond, which comes with bond conditions. So I see where you would get confused if the one before got returned to you, but we're back at it. They reissued this case.
I just don't even understand how they reissued the case because it was my brother kidnapped my kid. But it is what it is. I have my own issues with Taylor Police Department and everything else right now that I'm going through. So
Okay, well, you're the one that has the case, so you're the one that has the bond conditions in the jurisdiction of this court, Ms. Hall. Do you understand your bond conditions, yes or no?
Yep. I know that my lawyer requested discovery.
I'm not talking to you. There's no question. So give me 1 second. I'm looking the report over.
Ryan Lupica is the
Is there a place?
There's an address.
That's what I'm looking for.
It's Ryan
It's
Lupica.
on Marvin Street in Taylor.
Ma'am, give me a second.
I had explained to her that the court would require she have no contact with Mr. Lupica or his address.
Yeah, I just need for the
I
bond
don't talk
conditions.
to my brother.
Ma'am,
Okay.
enough.
Don't talk.
Honestly, you're just digging yourself a hole right now, so just stop.
I'm not doing anything.
Ms. Hall, it's easier.
Marvin Street.
Yes.
Okay. Okay, you're also gonna have no contact with Ryan Lupica or 13685 Marvin Street. When I say no contact, Ms. Hall, I mean no contact. That means you cannot email him, call him, or text him. That means nobody can do those things on your behalf. I see you're listening, but I don't need the attitude. You cannot send a text message, a tweet, an instant message, or anything of the like. That includes contact on Facebook, Instagram, Twitter, Cash App, or any form of electronic communication whatsoever. If you have him added on any form of social media, you are to delete him immediately. Sending a blank message is considered to be contact, since I'm instructing you to take specific steps to make sure that does not happen. If the communication comes from you or by the direction of you, it will be considered contact, and it will not be a defense that you accidentally contacted him. If he contacts you, you are not to reply. If he's at a public place, such as a store or a park, and you see him, you are to leave immediately. This is the order of the court. The victim in this case cannot change the order, only a judge can. If he were to invite you over or to ask to meet you anywhere, and you do so, that is a violation of this court's order. If we need to change this order at any point, we will have a hearing with both parties present. Do you understand that?
Yeah, my brother's dead to me. I don't talk to
This is one of the most common courtroom misunderstandings you'll ever see, and also one of the fastest ways to irritate a judge. Miss Hall hears the phrase, personal bond, and mentally translates that into no rules apply anymore. But that's not how bond works. Bond isn't freedom, it's conditional release. The court is essentially saying, we're trusting you to stay out of trouble while this case is pending. And that trust comes with strings attached. What's happening here is procedural, not personal. The judge isn't punishing her. They're formalizing conditions because the case is officially active again. And notice how the judge keeps slowing things down, explaining step by step, giving her multiple chances to simply answer yes or no. But instead of absorbing the explanation, Miss Hall keeps circling back to how unfair or confusing it feels. That's a dangerous move in court. Judges don't argue facts, they enforce procedure. And every extra sentence here is quietly burning goodwill she doesn't realize she needs later.
All right, Mr. McGregor, this is cause number CR 24172, and we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my car, and right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review, so currently I'm waiting for that to
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs, and I've got a few interviews scheduled as well. So
When are your interviews scheduled?
today and this weekend, or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have zero expenses. Because didn't you say you live with your father or something? Do you live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
But $1,300 doesn't help me get 10,000.
Here's where the confusion turns into resistance. The judge is clearly explaining that while the original charge was dropped, prosecutors retained the right to refile, which they did. Legally, that resets the process. Emotionally, though, defendants often feel blindsided. And that emotional reaction is exactly what we're watching play out. Notice how Ms. Hall isn't disputing the charge itself. She's disputing the process. She believes returning the bond meant the matter was closed forever. But the justice system doesn't operate on assumptions. It operates on filings. Once charges are reissued, the court has jurisdiction again, full stop. And instead of listening, she starts layering in unrelated grievances, police issues, family conflict, past frustration. Judges hear that as noise. The more someone talks past the explanation instead of engaging with it, the more likely the judge is to tighten control. This is the moment where cooperation could have reset the tone, and instead, we head straight toward friction.
It doesn't. It helps you. It would help me get 10,000, because that's $1,300 towards that 10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels. So that didn't last very long because I asked them questions about their policy, and they said that it wasn't working out. So,
How much are you paying your bondsman?
and what?
How much are you paying your bondsman?
The bondsman, I paid $5,000 total, but that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away, and I was driving too far. So I've been kind of up and down with jobs. Like, I've had 3 jobs the past year, and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm going to reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses, and you come back without a lawyer, we're going to have a hearing on your bond. I may find your bond insufficient that day, and I may put you back in jail. The longer you sit in jail, more likely you're going to become indigent to the point where I can appoint you an attorney. You see how that works? You're going to pay your bondsman $5,000. You're going to have a job, you're going to pay them $5,000, and you're going to get out of jail, but you're not going to hire an attorney to go forward on your case.
I would hire an attorney if I had 10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you've got a car, so you could drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks. If you don't have a lawyer in 2 weeks, then we're going to discuss your bond that day.
That line right there is judicial code for stop talking before this gets worse. And it's not said lightly. Judges don't warn people for fun. They warn them when patience is nearly gone. Up to this point, the court has explained bond, jurisdiction, refiled charges, and expectations. The frustration you're hearing now isn't anger. It's disappointment mixed with authority. And look at what's happening. Miss Hall keeps interrupting to clarify details that don't change the ruling. That's the mistake. Court isn't about winning an argument. It's about you understanding orders. Every interruption signals that the message isn't landing. When a judge says you're digging yourself a hole, what they really mean is that consequences are getting closer. And this is exactly the type of moment where cases suddenly gain stricter conditions, harsher warnings, or faster enforcement. The court is still calm, but the grace period is ending.
Bring him back in here when you get a chance, Fabio. Oh, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. You understand that?
I accidentally tried to over it the wrong way. I apologize.
I'm going to find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm going to appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm going to up your bail to $150,000, and I'm going to appoint you an attorney.
150,000.
Yeah, that's what I said. 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of a child charge that you have? Do you want that? Yes or no? No? Okay.
I apologize.
So good. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right. Go ahead and take him, and I'll send over an order.
Most serious moments in the entire hearing, even if it sounds procedural. No contact orders are not suggestions. They are legal landmines. The judge isn't being dramatic here. They're being precise. Every platform, every message type, every indirect attempt is being explicitly covered because violations are incredibly common. And judges know that. What's important to understand is that intent doesn't matter. Accidentally liking a post, sending a blank message, or having someone else reach out on your behalf can still land you in custody. The judge is closing every loophole before it's exploited. And when Miss Hall responds with sarcasm about her brother being dead to her, that tone doesn't help. Judges don't care about emotional declarations. They care about compliance. This is the court drawing a hard boundary. Cross it, and the next hearing won't be conversational. It'll be custodial.
All right, let's go ahead and bring in Mr. Weathers, please.
Good afternoon, Your Honor.
Good afternoon, Ms. Conley.
Did you guys need Weathers, or what was the last name?
Yeah,
Weathers.
that's my turn.
Okay.
All right, thank you. You are Casey Lee Weathers, is that correct?
Yes, sir.
All right, Mr. Weathers, I'm Judge Elsenheimer. I'm handling this matter today for Judge Hamlin, who's unavailable. This is an arraignment on a motion affidavit and bench warrant that was requested by the prosecutor's office in Grand Traverse County. And sir, you should understand that, well, before we get to that, let me identify who's here. On your behalf is your attorney, Ms. Conlon. Ms. Copeland is the court reporter. Ms. Henry is the clerk. Mr. Olson is here from the prosecutor's office as well. Sir, the allegation against you is that you had positive test results on the 13th and 15th of October. You had a testing regimen that was part of your bond. The allegation is that you violated your bond, and violation of a bond can be considered to be contempt of court, which can be handled criminally or civilly. If it's handled criminally, it's a separate criminal misdemeanor, carries up to 93 days in jail, a fine of up to $500, but you'd have all the same rights you have in every other criminal case, including the right to an attorney. If you can't afford an attorney, one would be appointed for you at the public's expense. You also have the right to a trial. At that trial, the prosecutor would produce evidence to establish that you violated your bond. The standard of proof is beyond a reasonable doubt. You'd have the right to present your own defense, and if you needed someone to appear, I would order that to happen for that defense. If I thought that the prosecutor or Judge Hamlin thought the prosecutor had met that burden, he'd find you guilty. If he thought they did not, he'd find you not guilty. Ms. Conlon, you've had a chance to discuss this matter with your client, correct?
I have, Your Honor. Thank you. Mr. Weathers would admit to the alleged violations at this time.
All right, thank you. So, Mr. Weathers, your attorney indicates that you're going to accept responsibility for the violations on those 2 dates. Is that correct?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir. I don't want you to talk about the domestic violence charge against you right now, third offense, or I suppose it's third or subsequent. We're not going to talk about that at all. We're only talking about this bond matter. Do you understand?
Yes, sir.
All right. The allegation is that you had test results on the 13th and 15th that were positive. It looks like they were positive for alcohol. Is it true that you used alcohol on those 2 days?
Yes, sir.
All right. So no surprise to you that you violated that you had positive tests on those
No,
days?
sir. Just
correct?
bad decisions, bad choices. That's it.
All right. I understand. All right. It's clear to me that you did violate your bond. I'm going to so find. Let's go ahead and have a conversation.